session.
Please be seated. This is the time set for argument in 1 CACV 210472 FC Gish versus Greyson. Counsel, good morning. We've read your briefs. We've discussed this matter in conference this morning. Each side has 20 minutes to prepare their arguments. When you begin your arguments, would you please state the party for whom you represent and address the remarks at the podium. It's your decision on whether or not you wear a mask. And with that, the opponent may go.
Your Honors, may it please the Court, Al Arpad for Jennifer Greyson. I'd like to reserve some time at the end, 4 or 5 minutes. There are some things I literally don't understand about the other side's arguments, so I'd like to reserve as much time as I can while still answering any questions you have. In going over the record for this, it really struck me how fundamental the errors are that we've alleged. We've alleged a lot of legal errors. They might seem technical at first, but fundamental to the system for setting parenting time in Arizona is that a parenting time order needs to be clear and definite in order to even be a parenting time order. That's not in any of the orders for the last 4 years. Instead, what's in the orders for the last 4 years is father shall have parenting time as directed by the therapist. Now that is a delegation to the therapist. It's pretty clear. There's no way to read the order any differently than that, I don't think. You also have this basic conflict between giving a parent sole decision making while that parent doesn't qualify for any parenting time.
Why is that?
Why is it a fundamental conflict?
The notion that which doctor to select isn't based on parenting time.
It absolutely is. If the father is able to make decisions and is not a danger to the child, he would have been entitled to substantial parenting time, definite parenting time.
So whether he goes to
ago.
Dr. Smith or Dr. Jones is dependent upon whether or not he have parenting time.
Whether he can have sole decision making is absolutely dependent on whether he can. But it's not dependent. There's no way you can make those two decisions fit together. He cannot have the level if he doesn't have enough level of responsibility to be able to be alone with the kid and have the parenting time is defined as the ability to have the responsibility to make routine decisions.
But we're not talking about routine decisions when we're talking about legal decision making. We're talking about such things as which doctor to attend, which dentist to go to, whether or not the child is going to be raised in a particular religion. I'm not sure how that it doesn't square with the ability, if the father has issues with the son, how does that impact whether or not the father can make rational choices on picking a professional?
First of all, the order isn't limited to just picking professionals. It's sole decision making across the board. Father gets to direct everything, which is, as we've said, illogical in terms of father not really even having contact with the child until directed by a therapist. But second, you get to the delegation issue. Father's not just picking a dentist. Father is picking the therapist who is going to essentially make the judicial decisions about when father has parenting time, because there is no definite parenting plan in place. Hasn't been for 4 years.
Well, let's stick with your first argument. That's something different, which is the delegation. But first, the statute does not preclude, would you agree, that sole decision-making could be placed with one parent who has supervised parenting time or no parenting time, and that the other parent would not have sole legal decision-making or joint, but would have all the parenting time?
No, I absolutely don't think you can.
Where in the statute do you see that?
We've given you the exclusive.
No, give me this. Don't tell me you've given. Where in the statute do you see that the court shall not.
The statute specifically, it doesn't say shall not. It specifically allows it allows the parent who has no decision-making whatsoever to have parenting time, but it does not provide for a parent who has no parenting time to have decision-making.
So let me ask you this. Dad's in the military, mom has passed away, unfortunately. Are you telling me dad, who is stationed in Iraq, can't have legal decision-making authority because he's not seeing the child at all? Because it's not a court order that's necessarily precluding it. You're saying that under any circumstance where the parent doesn't have contact with the child, that parent shouldn't have sole legal decision-making.
No, that makes it much more difficult, but that is a different situation. I'm talking about a court order that says that the father can't currently have parenting time except as ordered by a therapist. I'm not talking about someone who's on the other side of the country or has some other practical issue.
So it's not the contact problem?
The contact problem is a problem, but that's not the legal problem.
Okay, so your legal problem is that the father doesn't have a good relationship with the child.
The father has such a bad relationship with the child that even a judge who was trying super, super hard to repair that relationship still in 4 years has never ordered that father is entitled to any definite parenting time without supervision. That's a problematic relationship at best.
Problematic relationships exist whether parents are together or not, and the parents still parent the child and still make legal decisions regarding a child, right? Even if the parents are together.
Generally, I would agree with that, yes.
Okay, so here we just have father making the decisions, but he's got a bad relationship with the child. People with bad relationships with their children have existed since there have been children, and they have continued to make decisions. The law doesn't say that can't happen. In fact, the law protects that.
We're specifically are talking about a situation where there have been multiple final orders in this case. And one of the problems with some of these final orders is that the judge hasn't made definite findings about father's conduct. There are all kinds of issues about father's conduct.
But the judge has also dealt with mother's conduct, and you're asking us to completely ignore that.
I'm certainly not asking you to ignore anything. The brief is framed entirely in terms of what the legal structure of Arizona parenting time law and decision-making law will allow. We have not, frankly, I think a lot of the factual findings are pretty shaky, but that's not the basis of our argument here on appeal. It's entirely that you can't have an order like this. It can't exist under Arizona law. And if it could exist under Arizona law, you would then have the problem of it being changed to a different type of therapy, which father has selected with his apparent delegated power to choose who's going to decide his parenting time, changed from a TI to a COBE, which is a type of therapy that is specifically designed to work in a situation where you have definite parenting time. Yes, Your Honor.
Really, those are two separate issues, right?
Yes,
I mean,
the COBE...
The issue of whether either the original order or what I'll call the modified COBE order is effective is separate and inappropriate delegates authority, is a separate issue on whether or not the court can issue the parenting provisions of legal decision-making and parenting time the way it did here. I mean, those are two really separate issues, correct?
They are logically separate issues. If the first order gets struck down, then the COBE order has to be struck down because it's got nothing to sit on top of. So they're related in that way. But it's also important to understand that the COBE order is completely inappropriate for the type of situation that is outlined in the previous order, because the COBE is only supposed to exist, and this is described in that article that we've cited in the brief. The COBE order is only supposed to exist in a situation where you've got a clear, definite parenting time order, and then we're going to use behavior modification to get the kid to comply with the parenting time order. That's not even remotely what we have here. And so trying to bring in a COBE at this point is an actual substantive change.
So if the court had said it's equal parenting time, and what I'm going to do is in the COBE allow that to proceed to get there under the direction of the COBE, we're done. We've got a clear parenting schedule, and there's nothing wrong with it then.
That could conceivably be done if the court had ever made those types of findings.
That's my point.
Yeah.
Your only issue is it's that there's no clear order as to how much time father would have. But if the court had said father's going to have every other weekend, 2 weeks in the summer, but because of the relationship issues, we're going to let the Kobe decide how we get there.
No, I would not limit it that extremely. You've got at least one of the central concepts there, but there's a whole range of problems with these orders going back 4 years where father has never been able to get a single order that says, yeah, this is the
I'm
thing.
saying, let's say that that wasn't the case.
Okay.
So your argument is really, there's no definite parenting plan, but otherwise the Kobe's okay. If they had said from the beginning, equal parenting time, but the TI is going to help us get there. But that's where we're going.
That is my understanding of what a Kobe does. Yes, when you have a clear,
Okay.
definite parenting plan, the Kobe tries to enforce it.
I just want to make sure that, because that's a very different thing than saying Kobe's are a problem. You're saying Kobe's are okay. You're just saying it's got to have something underlying it. So we send it back. I don't know who the current judge is, but the current judge puts in an equal parenting plan, Judge Russell, and says, we're off, Kobe, go forth and do it. You have no claim.
Probably, I'd have to see the order, but yes, that's how a Kobe is supposed to work. You're supposed to have it.
Except I understood your argument to be you couldn't do that because you're still delegating the authority to the Kobe to determine when to increase the parenting time.
Well, again, as I said, I'd have to look at the order. If the order says, as of today, dad is entitled to parenting time, but the kid's not complying, that's what a Kobe is designed to remedy. If the order says, well, there are still all these problems, and so therefore I'm not really ordering equal parenting time, I'm ordering something different, that becomes a delegation issue, even if it was a lot less severe than it is in this case.
Just so I understand your argument, if the court said, I'm imposing equal parenting time, 50-50, and it picks the parenting plan that Judge Gus indicated, but then suspended it until it was recommended by the Kobe, that would be a violation of what you say was an inappropriate delegation of authority. Just because they gave them something doesn't mean, the way I understand your argument to be, is that who decides when it's appropriate to take that next step has to be a court, not a Kobe.
I think that's absolutely correct. It would be a less logically problematic order, but it would still be a delegation if it was as you described and you said you've got parenting time, but it's suspended for a while and the TI will decide when it's not suspended anymore. That would still be a delegation, even though the order would make a little bit more logical sense than the one we actually have here.
When you say, would it be an improper delegation at that point?
I would have to look at again, we're talking about a 15-page...
So you're saying it's conceivable?
I'm sorry, Your Honor?
It's conceivable, it could be, it's conceivable, it couldn't. You'd want to see the language.
Yes, Your Honor.
Okay.
And I'd want to see one of the problems with the Kobe order is that the original order has all kinds of observations, 15 pages of stuff in it. And the Kobe order, essentially, because it's a Kobe order, a lot of the language in it is very neutral, but if you look at what Dr. Weinstock says the concept of a Kobe order is that it's supposed to be basically unlimited fit parents, and now we're going to work on the kid and get them to comply with what the fit parents are telling them to do. That just isn't the situation we have at all. So
if we're looking at this, you're arguing our holding should be very narrow. Just when there's no fixed parenting plan in the Kobe, then that's an improper, or a TI, that's an improper delegation and leave for another day. What happens, with regard to a differently, maybe more finely tuned?
I think you need to rule a little more broadly on the original order in terms of can you have, well, all of the things I've outlined. I'm getting a little tight on time. In terms of the Kobe order, I think that you have to, you can rule quite narrowly there and say that the Kobe order appears to be a change that was beyond the court's jurisdiction at this point without having another hearing, and by the way, we were up on appeal at the time.
So where in the TI do you see that we need to rule more broadly on the delegation, as opposed to keeping it very narrow? When there's no parenting schedule, that's an improper delegation.
On that delegation issue, I think you could do it almost that simply. This is possibly the most, this delegation is way more than Nold versus Nold or any of the other cases. It essentially punting this off to the TI for 4 years and not even saying we're going to ever come back and change the existing rules. I don't want to completely ignore the issue of whether the trial court should have listened to the child here, to Greyson. It's not a complicated legal issue like the other ones are, I don't think, but when this gets back, he's going to be 14. And it just does, I mean, again and again, this judge, and he struggled with this. I understand he was frustrated. It's a very, very difficult situation. But over and over again, he says, well, okay, there are these incidents that happened. It's not even really disputed that the incidents happened. It's disputed how serious they were and whether mom is making the kid think it's more than it actually is and things like that. The judge, and it's in that Christopher K. case that we cited in our reply, the judge is required at some point to make actual findings about that. Okay, is this rising to the level of abuse? Is it, what's going on here? And throughout the 4 years, it really struck me, the judge has said, well, I've heard from the parents and I've heard from the TI and I can't decide who's at fault here, so I'm just going to continue this TI thing. It can't just punt on that. At some point, he's got to decide what happened, and he really should, at some point, talk to the kid to figure out what happened. It just doesn't logically make sense that he would keep doing that for such a long period of time. If you don't have any other questions for me, I'll reserve the rest of my time.
Thank you. Counsel?
Thank you. Good morning, Your Honors. Scott Rowley on behalf of Jeremy Gish. Mr. Gish hasn't seen his son Greyson since January of 2000. I represented Mr. Gish since 2017. In 2017, the parents agreed to equal time. And since that time, mother has attempted to remove and thwart father's parenting time to the effect of him not having seen his son at all, no contact in the last 2.5 years. None of this is what the court ordered. This isn't what Judge Coffey ordered. Judge Coffey, if you look at his most recent minute entry from 2021, he calls this the most difficult case that he's had on the family court bench, and that I think he says something to the effect that he's spent more time on this case than any other case. Judge Coffey never ordered my client to not have parenting time, which is what's happening. It's what's been happening for the past 2.5 years.
Well, did Judge Coffey delegate who gets to say that your client gets parenting time to the TI? Originally in the April 30th order, delegated the authority to the TI.
I don't agree. I don't think the authority for father's parenting time was delegated to anyone. The court made clear that the parties were ordered to return to equal time. In fact, they were ordered to return to the same schedule that they had agreed on, which was their original Rule 69 agreement, what was ordered at the time of the decree. That's what the judge ordered them to go back to. So the implementation of that parenting schedule is different than the order of the schedule. The order of how much time my client should be getting has always been equal, since before the decree until now, with the exception of a very short period of temporary orders.
He ordered supervised parenting time.
My client was the one who requested supervised time.
The court ordered it. That's the answer to my question, correct? And then the court ordered supervised parenting time, and they delegated that authority to the TI to determine when it should be increased to unsupervised parenting time and then ultimately equal parenting time.
The court gave the TI authority to scale it up and ordered to do it to equal time, yes.
And all of that, is there a case or a statute or something that would indicate that the court can delegate that kind of authority to a therapeutic interventionist?
So I think the most important case on this point is actually Paul E. So my client has sole decision making. This case is almost like Paul E. turned on its head, because unlike in Paul E. where the court was addressing restrictions on a sole legal decision making situation, this court is not allowing my client access to use his sole legal decision making. So he has sole decision making to appoint or to select an orthodontist, a doctor, anyone he sees fit, including Dr. Weinstock, to address his therapy. The point of the Kobe order is to give us an enforcement mechanism so that mother's actually required to show up and that there will be some teeth in the order. By Mr. Arpad's version of this, my client would have no relief. There'd be nothing for him to do here. The scenario, or the hypothetical that the court, I believe it was Judge Goss, put forward about if the court issued an order that said the parenting time is ordered to be equal and the parties are to use the Kobe order to implement that order, I think that's all that my client's asking for. That's all that we've wanted from the beginning.
And what about the TI order, same?
Well, there's been some struggle with the TI order. So if the record in this case shows that my client tried diligently, paid thousands of dollars to Dr. Corsten, and mother in this case refused to comply at all. And the court held her in contempt because she just told Dr. Corsten that she wasn't going to be there. So we need an ongoing process. We need something where there is follow-up, and that's what the Kobe order is intended to provide.
But the challenge there, from my perspective, where was the jurisdiction? How did the trial court have the ability to enter a Kobe order? There was a petition to enforce, not to modify. Are you saying that a Kobe is not a modification of a therapeutic interventionist order?
Kobe is not a modification of the therapeutic interventionist order, and the orders that Father has are much broader than that. So,
You know, Mr. Rowley, you say that, but it seems to be different. So what is the distinction that we would peg on what is a modification, what is an enforcement?
I understand that. So the court's order, the 2021 order,
They're both in 2021. So are you talking about the April 30th order or the August 18th order?
The August 18th order contemplates my client having the ability to select a provider in the future. It also contemplates that person being a therapist. At one point, it refers to that person as a therapeutic interventionist.
Could you cite to me the rule that says your client gets to make that decision versus the court? Because I thought the rule said that the court would select, would appoint the therapeutic interventionist.
Well, again, back to Paul E., I think that my client having sole decision-making, that he is allowed to pick those providers.
Well, except the rule says that if the court is to select the provider, then the court can order the parties to pay for it after making an on-the-record determination of ability to pay. But if your client is selecting, then what authority does the court have to order the other party to pay for it?
It's just like any other medical provider in a sole legal decision-making situation. The court's going to allocate the payment for it based on either the income of the parties or based on some other factor that the court finds appropriate.
But that's not what the rule says, is it?
About the payment specifically?
For therapeutic interventionists.
Correct. You're talking about Rule 95?
Yeah.
Yes.
The rule says that the court is going to do the appointing and then can order the parties to split it after making an on-the-record determination of the ability to pay. Is there another rule that I'm not aware of that would indicate that your client can make that determination?
Well, my client didn't make the determination. My client offered a proposed order to the court, and the court signed it, and I think that order was in accordance with...
Well, the court said you pick.
Okay.
Okay, so the court delegated its authority to your client.
I don't think the court delegated its authority to my client. I think my client has the authority to pick providers because he's a sole legal decision maker.
But not under that rule, he wouldn't.
Okay.
Well, so what rule does he have? Just in general, he can pick. And then then that would encumber the other party to have to pay.
I understand what you're asking about the cost of an appointee under Rule 59 or 95. I don't have an explanation for that.
Okay. Did this court make because the rule says the court is to make an on-the-record determination about the ability to pay. Did the court make an on-the-record determination on the ability to pay in either the TI order of April of 2021 or the August Kobe order?
I don't believe so.
So that, on its face, is an inappropriate delegation, and we should remand it for that point alone.
Well, I don't agree with that, but I understand the court's perspective.
Well, I mean, if it's required and the court didn't do it, then we're just supposed to say, oh, do whatever you want, don't follow the rules.
The court in this case made extensive findings about both of the parties' financial resources prior to this. So there had been a lot of, there's two existing attorney fees awards that Mother hasn't paid that's to the tune of something like $30,000. So if we're talking about the equities of the case, or who owes whom what, or who's paid more.
No, I'm just saying where the rules followed, and if not, what's the remedy?
I understand.
And your response would be?
I don't have an explanation for how that should be paid under Rule 95.
Okay. And let's talk about delegation of authority. I was looking back at the the April order, and it says, Father shall continue to have supervised parenting time as directed by Dr. Corsten until she determines the child is again ready to have unsupervised parenting time with Father. That appears to be a complete delegation of the court's function to determine when a supervised parenting time or unsupervised parenting time is appropriate. Don't you agree?
I don't agree because it was at my client's specific request. So if the court were ordering that over the objection of my client, I could see the argument, but my client was begging the court to order him to have supervised time and to implement these orders, because that's what's going to help him normalize his relationship with his son.
Okay, so the court has adopted that order and says, yes, you're going to have supervised parenting time. Isn't it still the court's responsibility to then determine when the parenting time should go from supervised parenting time to unsupervised parenting time?
I don't think so, because I think the court's already made that determination that Father is capable of exercising unsupervised time so long as it's therapeutically appropriate for the child. So, and this goes to Mr. Arpad's other point, which he raised several times, which is that
But then the order goes on to say, the party shall follow the recommendations of Dr. Corsten regarding Father's parenting time with the goal of gradually increasing his parenting time and eventually returning to an equal parenting time schedule once it is therapeutically appropriate for them to do so. So what the court is saying is, I'm washing my hands of this case, and I'm giving it to Dr. Corsten to determine when it's supposed to be supervised, when it's supposed to be unsupervised, and how many days of the week or when it's going to happen until the parties reach an equal parenting time.
I disagree with that. I would say that the court ordered that the parties are going to exercise equal time, and that the TI is there to help the parties get to that point, but it's really not anything being delegated to the TI.
They're supposed to, the very order says they're supposed to follow the recommendations of Dr. Corsten.
I understand that, but Dr.
And what
Corsten's-
happens if you disagree with it?
Okay. Dr. Corsten's being directed by the court to implement an equal schedule. So it's not up to Dr. Corsten of what the schedule would be.
It looks to me like that is the case. The party shall follow the recommendations of Dr. Corsten. So your client disagrees with Dr. Corsten. Does he have a remedy?
Does he have a remedy for what?
He disagrees with the recommendation of Dr. Corsten. 3 months after this is ordered, he disagrees with the remedy of the recommendation of Dr. Corsten. Does he have a remedy?
Sure, he could file with the court and allege some impropriety by Dr. Corsten. I'm not sure what you're asking. What's his remedy in terms of what?
He thinks that he's accomplished a goal and that he should go from supervised to unsupervised. And Dr. Corsten says, no, I don't think you're ready. Is it Dr. Corsten's determination that he is not ready, or is it the court's determination that he's not ready?
No, it's the court's determination.
So that's my point. This is a delegation of authority because it doesn't say it's the court's authority, it's Dr. Corsten's authority.
And I understand that perspective. I disagree because I think the court entered an order regarding equal time, and it was a specific order to go back to the same order that they had. So there is a specific order there that's ordered from the court that everybody was supposed to be aiming towards, and that's the point of the interventionist, isn't to write their own story about how this goes or to make any kind of ruling, but to therapeutically help these individuals to have better relationships.
But isn't the problem with your argument that there's no fixed schedule to get the parents to equal parenting time? It may never happen under this order.
I agree
And
that.
so, I mean, at a minimum, shouldn't the practice be, my order is 6 months from now, we're unsupervised, and by the end of the year, you're at equal parenting time, do your job and make this so? That wouldn't be an improper delegation, but don't you run into a problem when the court never gives a deadline to say when you're going to hit equal parenting time?
Yes, I do think that's a problem.
Okay.
Yes, that's a problem. It's a problem in a lot of these TI cases. I know, at least I know two of you judges here from being in front of you on family court. And the articles deal with this as well. When we're in a situation like this where a parent has become estranged or alienated from a child, the court, I hear what you're saying, but the court simply issuing an order and telling everybody to go and follow that's not effective. In a case where we need ongoing monitoring and ongoing responsibility and accountability from a party, there has to be some teeth in the process that allows us to go from no parenting time to a normalized schedule. So if that's not a TI, if that's not a COBE, I think it would be very helpful for the court to require a certain time frame. The problem with that is it's not going to be appropriate, and I don't know how the judge in a trial is going to understand, well, in 6 months it'll be therapeutically appropriate for this teenager to go back with their father or mother again. I don't know how the judge would make that determination from the bench.
And not to step on Judge Goss's toes, but I want to follow up. Isn't the remedy here that you say, in 3 months, this is what I want to see happen. In 6 months, this is what I want to see happen. In 9 months, this is what I want to see happen. And at the end of 3 months, if it's not appropriate, they can come back in and say, Judge, it's not appropriate. But it's the judge who determines whether it's supervised or unsupervised. It's the judge that determines, yeah, you reached milestone 1, so now we have to go to the next milestone. It's not this appointed expert that now has the authority. Isn't that the way it's supposed to work?
That is the way it's supposed to work. So that would be wonderful to have it work that way, and then when those orders are issued, then everybody complies and follows those orders. If people don't comply and follow those orders, if a child doesn't want to follow the parenting time schedule and they're resistant, I'm not sure that a judge saying, in the future, this is what's going to happen, is the right way to answer that question.
Okay.
I do want to address Mother's argument about fitness. I don't know if this is a concern of the court, but this is something that Mother's seemingly raised as if fitness is now a different concern or issue for the court to address. So Mother's concern is that the COBE order has a box checked on it that's saying both of the parties are fit parents. Fathers had decision-making from the time of the decree. Pursuant to the Nikhazy case, the term fitness is related to fitness to make decisions on behalf of the minor child. So there's really no, the argument that my client is unfit, it goes completely against the record. The credibility and the lack of honesty from Mother should be disturbing to the court. Mother's called Father, these are just a few that I've written down, a non-custodial parent who's been granted no parenting time, parent who cannot be trusted with parenting time at all, and a parent who has had little actual contact with the child. That's only because of Mother's contempt and because of her refusal to abide the trial court's order in allowing parenting time. That's the only reason why my client has been estranged. In this case, there's been so many orders of protection for mother, I've lost track, but the most recent one from 2020, she made some very outrageous allegations about the Superior Court admitting into evidence pictures which she claimed showed her completely nude. This was not a small point because the order of protection was what triggered mother's most recent denial of father's parenting time. So this was in July of 2020. My client had arranged everything with Dr. Corsten. He had a supervisor lined up. They had everything ready to go. And as he's going to exercise his parenting time, mother has him served with another order of protection. And one of the things on that order of protection was that in Judge Coffey's court, she alleged that we had admitted revenge porn that was doctored and altered. This is just one example of so many things in this case that have demonstrated that mother is not acting in good faith. Her arguments about the child should not have been given any weight, and my client is being deprived of his parenting time. In the last few seconds that I have here, I want to address the current posture of where this is at. So last year in October, we had approval from the Superior Court on Dr. Weinstock's order, and Dr. Weinstock was ready to move forward. That was in October. It's now May, and there's been zero parenting time, zero therapy that's taken place because of this court's order staying that therapy that father's requesting. Thank you.
All right, thank you, Mr. Rowell. Mr. Arpit?
Yes, Your Honor. Just a couple of points, and I'm happy to answer any questions you have about the different things that came up there. One of the important things to think about in how this is dealt with is that each of these orders, the initial dissolution order, then the 2019 order, then the first 2021 order, is a final order. It's in the form of a final order, and it pretty much supersedes the previous ones. This type of, as Judge McMurdy was discussing, this type of approach would make a lot more sense in terms of temporary orders than in terms of final orders. I think that type of ongoing supervision can be achieved through temporary orders. It's extremely difficult to achieve it through a final order like that.
But they do that all the time, don't they?
Yeah.
Don't they say when the child turns 6, this is going to happen, or when it will go to school?
That does raise the interesting question that was in the article that I submitted as a supplement, and it wasn't the basis of our appeal, but she does say, she really questions whether the court should be predicting what the future is going to be 6 years out, or whether you really got to go to court for a change of circumstances. I think that's an interesting question, but you probably don't need to reach it here because we've got the much more fundamental questions about delegation, which I think you're right on the money. This clearly is and isn't workable and can't be upheld.
But Mr. Arpad, what do you do in a situation? I mean, it seems to me like the court has to do something more than just, go and sin no more. There has to be some type of regimented, these are the things I want to see accomplished before the next step is taken.
We're talking about a child here with autism who has some real difficulties with instability. And honestly, at some point, I think the only thing you can do is say that the kid feels safe and secure with mom and does not feel safe and secure with dad, and he's just going to have to be with mom for a while. I don't see how making him continue to go to traumatizing therapy is ever going to fix the problem, if you want my honest answer to that. But if the next judge decides that that's what he's got to do one more time, then I guess we'll have to figure that out, whether it's Dr. Weinstock or whether it's somebody else. But the order that we have here is completely unsustainable on multiple legal grounds and has to go back and be done over. There's no way to blue pencil it into compliance because it just doesn't have the basics that are needed. And I think that's my main point, so I'll end on that if that's all right.
No.
All right. Thank you, counsel, for your arguments. The case will be deemed submitted. We'll issue a decision in due course.